police station for a period of 15 days to enable the applicant to complete investigations. Two, that the Honorable Court makes any orders that it deems fit. The application is based on the following grounds. The first being that the respondent was arrested on 14th of November after firearms, namely 2 Seska pistols and 1 mini Browning plus 57 rounds of 9mm ammunition were recovered following a search at his rural home in Uriri Sub-County, Migori County on 13th of November. That the respondent has failed to give a satisfactory account as to how the above firearms and ammunition came to be in his possession. It is suspected that he does not have valid certificates for possessing them. That investigations are ongoing, and also that if the respondent is released on bond, he is likely to interfere with the investigations. It is supported by an affidavit sworn by Inspector of Police Philip Sang, where he deponed that he is one of the investigators in the above matter. He repeated the above grounds in his affidavit, and he also added that investigations that are yet to be concluded include having investigators visit the respondent's rural home in the company of scene of crime officers, checking firearms data to determine the real owners of the real licensed owners of the firearms and ammunition, arresting other crucial suspects, obtaining phone data, recording witness statements, taking respondents' fingerprints. He averred that if the applicant is released on bond, he is likely to interfere with the investigations. Ms. Mwaniki for the state submitted further that the probable witnesses cannot be named for now. She said that since firearms were involved, it is a matter of public interest, as they could have been involved in the commission of other crimes. The application was opposed. The respondent filed a replying affidavit sworn on the 15th November 2018. He stated that he is a state officer serving as the governor of Migori County. That following a raid on his homes by Ethics and Anti-Corruption Commission officers, he was informed by one of his bodyguards, one Joshua Odoch, that 2 Seska pistols were found in a metal suitcase during a search at the guard house at his Rapogi home, and that one ESCC officer emerged from a room within the guard house waving a third pistol, which is the mini Browning. At the time of the said search, he was at his Lavington residence in Nairobi, where another search was going on. He and his bodyguards were asked to surrender their firearms, and they did so. The firearms were verified, then returned to them. He further averred that he and his bodyguards who were at Rapogi during the recovery have already recorded statements. He prayed that the application here be dismissed because of the following grounds: that the offense under investigation is bailable under Article 49, 1H of the Constitution of Kenya of 2010, and he is not a flight risk. He also said he shall abide by all terms of the bond or bail if granted, and that he has always cooperated and collaborated with security agents. He has never breached the terms of bond and bail before, and he will not interfere with the witnesses in this matter. Lastly, he said there are no compelling reasons have been brought forth to deny him his constitutional right to bail. The respondent's counsel, Mr. Sagana, in addition to the above, submitted that the said firearms were not in the respondent's home but from a guard house which was in possession of police officers. That following bail terms granted by the High Court in another matter, the respondent has not gone to his Rapogi home and has no intention of going there nor interfering with witnesses. Further, that investigations here could go on without the respondent being detained. That despite the progressive 2010 constitution, the state just wants to punish its citizens and subject them to public humiliation. Since the witnesses have not been disclosed, the respondent cannot interfere with them. He also submitted that Section 36 of the CPC limits the rights of liberty, but Article 24, Sub-Rule 2, Sub-Article 2C of the Constitution provides that interpretation of a constitutional right by a statute should be done in a manner that enhances the constitutional right. He further noted that no charge or holding charge have been preferred for now, so the investigations can continue, and even if the accused person is charged, they can still continue investigating. He asked the court to uphold the Constitution. Mr. Ombeta, who is also appearing for the respondent, added that any continued detention of the respondent is against the Constitution. He said Article 19 states that fundamental rights belong to an individual and are not granted by the state. Further, he said that in the at the Rapogi home, there are several relatives living there of the accused, since it is an expansive homestead, and it was not clear why the respondent was the one picked to account for the said firearms. The respondent was submitted is not needed for the investigation activities named by the state, namely the confirmation of the firearms data, mobile data, arresting other suspects, and others. He further relied on Article 20 and 21 of the Constitution. He contended that this was not a public interest matter, as the prosecution has not explained why or how it is. Now, I've explained the statutory and the constitutional provisions that provide for bond. These are Section 123(1) of the Criminal Procedure Code, which states, and I quote, when a person other than a person accused of murder, treason, robbery with violence, attempted robbery with violence, and any related offense is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court and is prepared at any time while in the custody of that officer or at any stage of the proceedings before that court to give bail, that person may be admitted to bail. End of quote. Article 49(1)(h) of the Constitution of Kenya of 2010 provides, and I quote, an arrested person has the right to be released on bond or bail or on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. End of quote. The Kenya judiciary has also issued guidelines on bail and bond, and it states that the courts in Kenya are enjoined to be guided by the gazetted bail and bond policy guidelines. On page 8 of these guidelines, it says that bail and bond decision making shall be guided by the following principles, which are derived from international best interests. They are the right of the accused to be presumed innocent, B, accused person's right to liberty, C, accused obligation to attend trial, D, right to reasonable bail and bond terms, E, bail determination must balance the rights of the accused person and the interests of justice, F, consideration for the rights of victims. The defense, together with the aforementioned respondents replying affidavit, filed a list of authority listing the following authorities. That is the Migori Okoth, Wais Abdulaziz. I'll not quote the quotation. I'll not give the full quotation. And the one for Gladys Wambui. I have read all of them and taken them into consideration here. The issue now for determination is whether the investigators here should be granted leave to continue detaining the respondent for a further 15 days to enable them finalize their investigations. From the above statutory and constitutional provisions, it is clear that any arrested person is entitled to bail or bond before or after being charged in court unless there are compelling reasons not to grant bond. There are many authorities that support this stand in Kenya, and I will only mention one due to time limitations. That is the one of Republic versus Danson Ngunya, and another which is 2010 Kenya Law Reports. From other jurisdictions, I'll quote one case. From Uganda, in High Court Criminal Application number 23 of 03, Tigawalana Bakali versus Uganda, the court stated, and I quote, bail is granted to an accused person to ensure that he appears to stand trial without the necessity of his being detained in custody in the meantime. The effect of bail is merely to release the accused person from physical custody, but he is still under the jurisdiction of the law and is bound to appear at the appointed time and place, end of quote. The respondent here is the governor of Migori, hence a prominent person, as already stated before. The state is of the opinion that he will be able to interfere with the witnesses and the entire investigations if released on bond. That this matter being a public interest matter, the investigators have to thoroughly investigate whether the weapons found might have been involved in other crimes. The court therefore has to ask whether these are reasonable or compelling reasons to deny, whether these are reasonable or in fact compelling reasons to deny bond. It was stated by the respondent that the said Rapogi home is one of the places he was barred from through bond terms issued by another court, and he has no intention of going there. That he and his bodyguards have already recorded statements, and I also note that the officers who are said to have recovered the weapons are from the ENCC. There is a very remote possibility that the respondent will be able to influence these officers. As for the other witnesses who could have been at the Rapogi home during the recovery, the state has, as of today, had at least 3 days from the date of recovery to record their statements, visit the scene, take photos, and continue whichever investigations needed at whatever investigations needed at the home. Any further investigations, like a confirmation of firearm data, mobile phone data, and others, do not require the respondent's incarceration to be undertaken, as he has no control whatsoever over them. And still on the said witnesses, on the issue of witnesses, so far none has been identified. So in my opinion, it will be hard for the respondent to interfere with these unknown witnesses. So far, the most probable charges the respondent is likely to face are those under the Firearm Act, which are all bailable. And from the judiciary's bail bond policy guidelines, I find that the most important one and relevant one in our case appears to be that of the presumption of innocence. And I'll quote a case here, R versus Danford Kabage Mwangi, 2016, KLR, and it was held, like quote, granting bail entails the striking of a balance of proportionality in considering the rights of the applicant, who is presumed innocent at this point on the one hand, and the public interest on the other. The cornerstone of the justice system is that no one will be punished without the benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to assure that the accused person will appear for trial and not to corrupt the legal process by absconding. Anything more is excessive and punitive. End of quote. Way back in 1951, the Supreme Court of the United States observed in the case of Stark versus Boyle, 342 U.S. 1-4 of 1951, and I quote, unless the right to bail before trial is preserved, the presumption of innocence secured only after centuries of struggle, would lose its meaning. End of quote. It is now my conclusion that the prosecution has failed to establish that the investigators should continue holding the respondent in custody. There are no compelling reasons shown to justify the denial of bond here. And after considering all the factors here, I am satisfied that the respondent is not a flight risk and will appear for trial if need be, and is not likely to tamper with the evidence or witnesses. I now therefore make the following orders. Number 1, the application here is dismissed. Number 2, the respondent is granted bond of Kenya shilling 500,000 with a surety of a similar amount or a cash bail of 200,000. 3, the respondent is ordered not to interfere by himself or his agents with the ongoing investigations, failure of which the bond here will be cancelled.
Can we just make one request? That we have reporting orders, that he should be reporting to the investigating officers at least once or twice a week or every Friday, pending the conclusion of these investigations.
Your Honor.
To report to
the Special Crime Prevention Unit, the in charge of Special Crime Prevention Unit, every Friday.
Here in Nairobi?
Yes, in Nairobi, as they are the lead investigators.
Your Honor,
yes.
That application is opposed for the following reasons. Number 1, the respondent is a state officer holding a constitutional office which requires him to be there from time to time. Number 2,
require him to go to Migori.
yes. Number 2, Your Honor, the respondent is a subject of the High Court adjudication, where some of the mentions fall on a Friday or on the same day. And there could be conflict of those directions, Your Honor. Number 3, Your Honor, it's unreasonable and unjustified in a democratic society where there is the concept of separation of powers. Let them do investigations, but whenever they want the subject, maybe once in a month, we don't have a problem. They can always give him notice and they will appear. But to require him to appear every week is punitive, is inhuman, degrading, and Your Honor, it will be an embodiment of impunity. And Your Honor, this much of the ODPP and DCI is impunity at work. This is what is bringing all this mess.
Your Honor, may I ask my learned friend if he has any evidence contrary to that, and I am opposed to them actually trying to imply anything else. Yes. No, I'm objecting to that line, Your Honor. And let it not go on record, because, and he needs to apologize, because, and unless they have any evidence showing that the two institutions are working beyond their mandate.
I had just started writing, it's inhuman.
Yeah, let me finish, Your Honor. He has a right to reply. Your Honor, I'm saying this is an embodiment of impunity. That's what I've said, and it should go on record. The merger, the unofficial merger of the DCI and DPP's office is unconstitutional, first and foremost. And we are saying that to require the subject to report to investigations every Friday would be inhuman and degrading, because it does not add value to a ballistic analyst report who can do that in an office or in a conference room. It doesn't require the input of the respondent to do that. So what we're saying, the Constitution contemplates separation of powers. Let all these state agencies execute their constitutional mandate independently and bring the evidence to court. The subject cannot help them or assist them in any way whatsoever to prove their case. He can even keep quiet. He has no obligation, he can even keep quiet. If they have no evidence, they shut their mouth. If they have evidence, they bring it to court. So we're saying, Your Honor, this court should not assist these state agencies who are demonstrating impunity of its worst form and the manifestation to come and say they want a court order to compel him to be appearing every Friday. That will be unconstitutional. It will go against the fair principles of fair trial, because now it's the subject of the court. But Your Honor, the subject is ready to and willing to comply with all terms that have been already pronounced by the court. But anything administrative would be unlawful, would be unconstitutional, and against the international good practice. For those reasons, Your Honor, we urge the court to reject. But if it wishes, it can impose once a month. The respondent is ready to appear before any officer to answer any questions. Your Honor, my colleague are now in.
Naam, barabara kabisa. Kwa tumekwenda katika kingo zile za mahakama, kwa ambapo kunafuatilia kwa karibu zaidi ni kwamba hatimaye judge ameweza kuamua kwamba hakuna mshukiwa ambaye ana sababu ya kunyimwa dhamana, kumaanisha kwamba ameweza kuachiliwa kwa dhamana ya shilingi 500,000 na kiasi kama hicho, na baadaye tutakuwa tunakueleza mengi kuhusiana na siku gani ambapo kesi hiyo itakuwa inatajwa rasmi kuweza kusikilizwa.